Illinois, Mr. Jackson is recognized for 60 minutes as the designee of the Minority Leader.
Madam Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include any extraneous material on the subject of this special order.
Without objection.
Madam Speaker, it is with great honor that I rise today to co-anchor this Congressional Black Caucus Special Order Hour, along with my distinguished colleague, Representative Terry Sewell of the great state of Alabama. For the next 60 minutes, members of the Congressional Black Caucus will have an opportunity to speak directly to the American people on the subject of the Shelby versus Holder and the American Voting Rights Act, specifically the John Lewis Voting Rights Act. On an issue of great importance to the Congressional Black Caucus, Congress, and constituents we represent, and all Americans. It is now my privilege, Mr. Speaker, to yield to the Honorable Congresswoman Terry Sewell from the great state of Alabama. I thank you, Congresswoman Sewell.
Today, we in the Congressional Black Caucus gather to observe the 11th anniversary of the Supreme Court's Shelby County versus Holder decision and to reflect on the state of voting rights in America. It was exactly 11 years ago today when the Supreme Court's conservative majority gutted the heart of the Voting Rights Act of 1965, eliminating voter protections and removing federal oversight from states with a proven record of voter discrimination. We have seen in those 11 years, 31 states institute at least 103 new laws to restrict voting laws. And it is no surprise that those laws disproportionately target African American and minority voters. The consequences of the Shelby decision have been clear and devastating. Long lines, strict ID requirements that require time and money to obtain, closed polling stations in communities of color, bans on early voting and absentee voting, the purging of voter rolls, and the list goes on and on. In my home state of Alabama, lawmakers have recently made it a felony to assist someone with their absentee ballot. While these tactics may be new, we know that they are borrowed from the same playbook that has been used for generations to silence the voices of African Americans and other minority voters. While black voters may not need to count the number of jelly beans in a jar, modern-day barriers to voting are no less pernicious than the poll tax and the literacy test of the past. In Shelby versus Holder, the Supreme Court was clear that the onus was on Congress to come up with a modern-day formula to determine which states are subject to federal oversight. Well, I'm proud to say that we have done just that. Working together with our nation's premier civil rights and voting rights organizations, we have come up with a modern-day formula to ensure states and localities with a recent history of voter discrimination are prohibited from restricting voter access. We even named it after our late, great colleague and hero, Congressman John Lewis. The John R. Lewis Voting Rights Advancement Act, which we introduced for the 5th time in September, will protect the rights of every American to vote. But despite our efforts, our colleagues across the aisle have continued to block these efforts from being considered. The fact that voting rights has been a partisan issue is frankly baffling to me. After all, the Voting Rights Act of 1965 was reauthorized not once, not twice, but 3 times with broad bipartisan support, most recently by President George W. Bush. Yet all of a sudden, our colleagues across the aisle have abandoned the issue of voting rights, choosing instead to spread disinformation and misinformation and to sow doubt about voters and the integrity of our elections. It is sad, Mr. Speaker, and it is shameful. As elected officials, we should be working tirelessly to ensure all Americans are able to vote instead of picking and choosing who can have access to the ballot box and who cannot. Mr. Speaker, this fight is extremely personal for me. It was in my hometown of Selma, Alabama, nearly 60 years ago, where foot soldiers like John Lewis risked their lives on the Edmund Pettus Bridge for the equal right of all Americans to vote. They prayed, they protested, they bled, and some even died for that right. It was their sacrifice that gave us the Voting Rights Act of 1965, the crown jewel of the civil rights and voting rights movement. Those foot soldiers were ordinary Americans who had the audacity to make this nation live up to its highest ideals of equality and justice for all. They leave behind a strong legacy of courage and sacrifice, and we must ensure that it was not in vain. It was John Lewis who told us that the right to vote is precious. It's almost sacred. It is the most fundamental nonviolent tool in our democracy. Mr. Speaker, our vote is our voice, and our democracy is strongest when every American is able to make their voices heard at the ballot box. So as we gather to observe the 11th anniversary of the Shelby County versus Holder decision, let us draw courage from the sacrifices of our foremothers and our forefathers. We are not asking anyone to put their lives on the line. We are simply asking our Republican colleagues to have the political courage to do what is right. We in the Congressional Black Caucus are demanding that Congress take up and pass the John Robert Lewis Voting Rights Advancement Act, and to do it without delay. We are united in this fight, and we are ready to get into some good trouble. I thank the gentleman from Illinois for yielding me this time, and I look forward to a rigorous occasion in which we talk about the importance of today being the 11th anniversary of the Shelby County versus Holder decision, and our need to pass in immediate terms the John Robert Lewis Voting Rights Advancement Act. We in the Congressional Black Caucus are ready to get into some good trouble, and tonight I know that we will make sure that this good trouble is put to good use. Thank you, and I yield back to the gentleman from Illinois.
I thank the gentlewoman, Congresswoman Terry Sewell from the great state of Alabama, and I wish to be totally associated with all of her great remarks and scholarship. Mr. Speaker, I rise today because 11 years ago, the Supreme Court of the United States proved that it lacked the judicial imagination befitting an institution clothed with immense power. As 11 years ago, the Supreme Court gutted the Voting Rights Act of 1965. And frighteningly, 11 years ago, the highest court in the land decided that racism had magically evaporated in America, and that hatred had somehow receded quietly into the history of the Republic, never to be seen or heard from again. 11 years ago, 9 judges on the Supreme Court decided that they were social scientists with a particular expertise in racism and the politics of voting. And instead of being judges who were hired by the American people to decide the constitutionality of a law, they rather took the position that the court knew more about voter suppression than the people who have dedicated their entire lives to the subject. 9 judges on the Supreme Court, Mr. Speaker, thought they had a better working knowledge of the state of racism in America than people living with it every day. But I rise tonight to declare emphatically that nothing could be further from the truth. This Supreme Court does not know more about racism in America than do the people who are the survivors of it. The members of the Supreme Court are not experts on everything. They are not omniscient. They are not infallible. They are not beyond all moral and political reproach. In fact, based upon what we have recently heard about certain members of the Supreme Court, it would seem that the complete opposite, in fact, is true. When it comes to the Supreme Court, as it is currently configured, fallibility abounds. And I rise tonight, Mr. Speaker, because the elected representatives of the American people cannot allow 6 unelected and seemingly uninformed individuals to undo the moral and democratic gains won by the civil rights movement over 50 years without doing something about it. All over this country, we have seen the disparate impact that the Shelby County decision has had on voting access in America. And what was once thought to be a regional problem has now metastasized and become nationalized. Since the Shelby decision, every region of this country is struggling to overcome novel attempts at voter suppression and the like. And regrettably, 11 years ago, those of us in the civil rights community told the leaders of this nation what was going to happen. What we told America, that gutting the Voting Rights Act would cause voter suppression to spread like a virus in a second-grade classroom. And that's exactly what has happened. That's exactly where we find ourselves today. And those of us who believe that the only threat to democracy are events like unto those on January 6th are painfully naive. The greatest threat to democracy isn't the outright violence that takes place when citizens who are motivated by lies engage in hand-to-hand compact with one another, but rather by the legalized and the systemic unraveling of the cherished democratic norms. But those of us who love America cannot sit idly by and allow the darkness of bigotry to once again embed itself into the electoral systems of this country as it once was. Those of us who have a constitutional mandate to establish justice, ensure domestic tranquility, and secure blessings of liberty cannot allow what African Americans did to expand the general welfare of the country's commitment to opportunity be erased. Nothing is more indelible and inherently fundamental to the success of a thriving democracy than is the equality of a citizen's right to vote. Because in America, voting is the manifestation of citizenship. In this country, if you cannot vote, you are not a citizen. And what most people miss about the civil rights movement is that at its core, it was an attempt to empower African Americans with the rights afforded to us by virtue of our citizenship. The right to vote is our birthright. And yet hundreds of years, this country denied African Americans born in this nation what was legitimately due to them. And it is only through blood, sweat, and tears that African Americans were able to fight in every war to once again try to regain full citizenship. It was only because people who were willing to give their lives that black people in this nation can cast a ballot for the candidate of their choice, and we are not going to let anyone take those rights away. Reflecting upon Shelby versus Holder, 11 years later, I'd like to quote the Assistant State's Attorney General Kristen Clark. She said, "This anniversary provides an important opportunity to reflect upon the profound consequences of that opinion in Shelby County versus Holder, which struck down the key provisions of the Voting Rights Act of 1965 and left millions of voters of color without the mechanisms that had stopped voting discrimination before it could be implemented. When President Lyndon B. Johnson signed the Voting Rights Act into law, he described it as one of the most fundamental laws in the entire history of the American freedom. The Voting Rights Act was a product of bold actions by Congress. It forcibly addressed the problem that nearly a century after the Reconstruction Amendments, millions of Americans were still denied the ability to cast their vote and participate in our democracy because of their race. One of the most important pieces of the Voting Rights Act that was taken away was Section 5, its pre-clearance requirement, enacted in 1965 and reauthorized by Congress in 1970, 1975, 1982, 2006. Section 5 required jurisdictions that had a history of voting discrimination to obtain approval from the Attorney General or a federal court before implementing changes in election procedures and practices. Covered jurisdictions could not implement their proposed voting changes until they had received pre-clearance. Thanks to Section 5, jurisdictions that tried to make changes that had a discriminatory impact were adopted with a discriminatory purpose were blocked from doing so. More than 800 proposed changes were altered or withdrawn in the period after 1982 alone. A repository of the Department's Section 5 objection letters, which provided an official record on each objection as well as the basis of the decisions, can be found. The Shelby County ruling marked a significant turning point for voting rights in the United States. In its decision, the Supreme Court invalidated, on constitutional grounds, Section 4B of the Voting Rights Act, which provided the formula for determining which jurisdictions were covered under Section 5. Without that formula, all jurisdictions were released from coverage overnight. Section 5 was rendered effectively inoperative, freeing states and localities to enact voting laws without federal oversight. States wasted no time implementing election changes that had not or might not have been survived the pre-clearance requirement. On June 30th, 2025, the very day the Supreme Court issued the Shelby County opinion, Texas officials announced that they would implement a discriminatory and burdensome photo identification statute. And on June 26th, the day after the Shelby County decision, Senator Tom Opakar, chairman of the North Carolina Rules Committee, publicly stated that North Carolina legislature would be moving forward with an omnibus law imposing multiple voting restrictions. Why weren't they trying to expand voting? They said we will use this decision to restrict voting. In the absence of pre-clearance, the statutes went into effect, and the departments, along with private parties, had to file suits under a different part of the Voting Rights Act to enjoin them. Mr. Speaker, states have adopted photo identification requirements, limited those who can provide assistance at polling places, reduced options for early voting, closed polling places, and unfortunately, Justice Ruth Bader Ginsburg proved prophetic when she observed in her Shelby dissent that ending pre-clearance was like, and I quote, throwing away your umbrella in a rainstorm because you are not getting wet, close quote. And without Section 5, new laws can be challenged only through long, protracted, resource-intensive, case-by-case legislation and fights. The John Lewis Voting Rights Act is the most fundamental piece of legislation pending before the United States Congress, and it must be enacted with all deliberate speed. This is something, Mr. Speaker, we must do. Securing the right to vote is the moral obligation we have to the principles of America and to whatever we believe is a future worthy of our children. And let me remind my colleagues that the progenitors of suppression do not stop with their initial targets. Today, the votes of African Americans are being suppressed all over the nation, but tomorrow it might well be yours. Do not forget the lessons of histories. The people who are coming for our rights will never be satisfied with what they have attempted to do to us. Soon they will look for new targets. That is to say, new objects of their resentment, their ridicule, and their scorn. But what the Supreme Court and Shelby decision has reinforced in no uncertain terms is the fact that elections have consequences. The inability to elect a Democratic president in 2016 led to this horrible decision, and those of us who stand on the precipice of a national election must remember this invaluable lesson. Let us not forget in 2016, the woman with the most votes did not win the presidency. Whatever policy differences we may have with the President of the United States, we cannot allow the protection of our civil rights to be left in the hands of judges who so ideologically are motivated that they are unapologetically fly insurrectionist flags upside down at their homes. And the only way to protect America from the conservative judicial fanaticism of the Supreme Court is to re-elect President Joe Biden and Vice President Kamala Harris. There's simply no other way for us to go. So let us do what we must do so that justice will roll down like waters and righteousness like a mighty stream. Mr. Speaker, you've heard from my distinguished colleague, the Honorable Terry Sewell from the great state of Alabama, and on this topic for the John Lewis Voting Rights Advancement Act. Mr. Speaker, all issues of great importance to the Congressional Black Caucus, our constituents, Congress, and all Americans tonight. With that, Mr. Speaker, I yield back.
The gentleman yields.
Mr. Speaker, I motion to adjourn the House. Nope. Back to my colleague, the Honorable Terry Sewell from the great state of Alabama.
The gentlewoman from Alabama is recognized.
So, Mr. Speaker, as we conclude our special order hour on this very important day, the 11th anniversary of the Shelby County versus Holder decision, we issue a call to action. We in the Congressional Black Caucus understand that the vote is the most fundamental tool of our democracy. And I cannot believe that 60 years after John Lewis was bludgeoned on a bridge, yes, 60 years after he was bludgeoned on a bridge, that my colleague and I stand here today to talk about restoring the full protections of the Voting Rights Act of 1965. It tells us that progress is elusive, and every generation has to fight and fight again in order to hold on to the progress that we've made and to extend it. John Lewis reminded us that ours is not a cause of one day, 1 week, 1 month. No, our struggle is a struggle of a lifetime, and everyone must do their part. Well, we here in the Congressional Black Caucus are doing our part. We are signing off and making sure that everyone understands that the alarms are going off. The alarms are going off because every American does not have equal access to the ballot box. We see states all across this country that are imposing more restrictive voting laws. Voter suppression has become the cause of the day, and we must do our part, and our part is to pass the John Robert Lewis Voting Rights Advancement Act and to fully restore the full protections of the Voting Rights Act. Now, we know that the Supreme Court told Congress that we must come up with a modern-day formula. Well, that's exactly what this bill does. It has a look back of 25 years. We're not trying to make Alabama and Mississippi be held accountable for what happened in the 1960s and the 1950s. No, we're talking about 1997 and moving forward. We're talking about recent acts of discrimination, voter discrimination. And we know that if we look back to just 25 years, we would even look back 15 years. We know that there will be jurisdiction after jurisdiction that still has suppressive voting laws. And as long as states are suppressing the right to vote, I believe that we have a moral obligation in the federal government to provide oversight. We know that that oversight is critically important, and that's exactly what the John Robert Lewis Voting Rights Advancement Act will do. And as I take my seat, I want it to be heard around this nation that we in the Congressional Black Caucus will not rest. We will not rest until we pass the John Robert Lewis Voting Rights Advancement Act. And to the gentleman from Illinois, it has been a pleasure talking about this most important topic. I know that I've welcomed you and your father time and time again to Selma, Alabama, to cross that bridge one more time. We know that a very frail John Lewis, with a body riddled of cancer, took to that bridge one more time in 2021. And he told us to never give up, never give in, that ours is a just cause. And because of that, we stand tall, the Congressional Black Caucus, in our commitment to never go back to those days. We need to pass the John Robert Lewis Voting Rights Advancement Act, and with the help of the Congressional Black Caucus and the gentleman from Illinois, we will do just that. Thank you, and I yield back my time.
I thank the Honorable Congresswoman Terry Sewell. Mr. Speaker, I would like to yield the controlling balance of my time.
The gentleman yields.